Welcome to In Your Defense, Galveston and Beyond.
Welcome to Defense on the Coast with Mark Diaz, a passionate criminal defense attorney with over 25 years of experience defending the rights of Texans. I'm Lisa Mosby, and today we're talking about bond conditions. Mark will explain what they actually mean in Texas, how they're set, and why understanding them can keep a case from getting worse. Welcome, Mark. Thanks for being with me today.
Hi, Lisa. Thanks for having me.
Pleasure. When someone is arrested and released on bond, what does bond conditions actually refer to under Texas law?
Almost anything. The case law almost says that a judge can make any conditions of bond that they want. More practically, it usually is something like we have one judge locally who, if you are charged with a drug case, she is going to put bond conditions on you that you have to drug test randomly. Another one that we see often is in family violence cases, protective orders or bond conditions that you can't be near the victim or the complaining witness in the case, those types of things.
And that makes sense. Judges in Galveston, Chambers, and Harris counties all have their own approaches. What tends to influence the conditions they put in place at the very beginning of a case?
Sometimes it could be the officer. If it's a family violence type situation or if it's a victim case at all, sometimes the officer will ask the victim, do you want a protective order? Do you want bond conditions? And if they say yes, then they'll pass that on to the magistrate. Some judges, it's just going to be a policy depending upon the charge. Like I said, we have a local judge who on all drug cases, she puts bond conditions for drug testing. So there's not, I want to say they look at it individually, but that's not really the case. They tend to do it on every family violence case. And then like I said, that one judge tends to do it on every drug case. And there's oftentimes that we have to go to court and ask for concessions or have hearings. Maybe a protective order was put in place that the victim didn't want, and it causes now family problems. Or a lot of times, if it's family violence, they'll include the children when the complaining witness spouse didn't want to include the children. So we have to go to court and address that as well.
Some conditions are standard, but others are more restrictive. What are the common conditions people should expect when they're released?
So it depends whether you are on a pretrial release or whether you go through a bonding company. Pretrial release in Galveston County is going to make you check in telephonically on a regular basis. Again, if it's a specific condition like drug testing, then they can test you at random. Some courts only do it when you have court. The drug testing, the no contact, I wouldn't say that there's anything standard because each judge is different and has their own cases that they feel like need bond conditions, whereas some courts don't put bond conditions on anyone.
The word that comes to mind is guidelines. It seems like many of these things are guidelines, and then the individual judge actually works within those. I'm sure there's cases where bond conditions feel confusing or overly broad. How do those issues usually come up, and what problems can they cause down the line?
Well, so typically the problems they can cause are just going to be the threat to revoke your bond and put you back in custody. There are some judges that if they drug test you and you test positive, the standard procedure is to just put you back in jail and double your bond, and you have to make a new bond to get out. We had a judge that if you tested positive for certain substances, he would put you in jail for 3 days and then bring you back and ask you, tell me what you learned. And if you answered appropriately, then he would let you back out. But the biggest long-term consequence in a case typically would be If it was something to do with a complaining witness or a victim in the case and a bond condition was not to talk to them, then obviously you're going to have your bond could be revoked, but now you're going to have problems with possibly trying to intimidate a witness or things like that. So it's going to depend on the condition as to what the long-term effects could be. But obviously the immediate is the loss of your freedom again.
Sure. Violations can happen unintentionally, like missing a check-in, traveling without approval, or misinterpreting a restriction. What are examples of situations that lead to violations even when someone isn't trying to break the rules?
I have a good example that happened recently. My client, there was actually a protective order against his wife, but it specifically did not include the children. They were in the process of getting a divorce. And so the family court had issued an order that my client could pick up the children on, X days of the week for visitation. But the criminal court had a condition that he couldn't go within X number of feet of her house. And he was on a GPS monitor. And so obviously he went to pick up the kids, and it showed a violation that he went inside the no contact zone. And that did not lead to a problem. It did lead to a violation report, and we had to go to court and explain the situation. The prosecutor called the wife and verified that there was no contact. He merely went, and she sent the kids out to his car. And so we didn't have a problem, but it's a good example of how it can potentially be a problem.
Yeah, there's a lot to know in these cases. When a violation is alleged, what tends to happen next? Walk us through what the court looks at and how quickly things can escalate.
So typically, and when I say we, I mean the defense is notified of a bond violation report. So is the court. The court will then say, depending upon how the court feels about the severity of it, will then send an email that says, Mr. Diaz, bring your client to court tomorrow, bring your client to court, whatever day. And then we have to go and have a hearing to address it. And obviously the fear is that your client will go into custody. So whenever we get a bond violation report, the first thing I do is call my client and say, well, what happened? Tell me, help me address this so I can be your voice. But
And then the escalation.
Right. And then depending upon the situation, obviously I've been in the situation where the bond violation was valid and my client did go into custody. Then I have to beg for a new bond, figure out a way to get my client back out of it. But yeah, it's just something we deal with.
Wow. What a scary situation to be in, sitting there not knowing what's going to happen. In cases involving alcohol, drugs, or family violence, courts sometimes add extra requirements like scram devices or no contact orders you mentioned. What makes these conditions more demanding, and how do they affect day-to-day life?
So the scram device is demanding because it's a wearable device and you have to pay for it. It's not free. And so it's an expense, obviously, that you might not have been prepared for. It's the same thing with putting the breath machine in your vehicle. It's an expense that you now have to go through. And then having to blow into the apparatus. The problem with these and the scram is that if you use drugs or alcohol on the scram, you're going to get caught because it's going to register. If you drink alcohol and blow into the intoxilizer, then it's going to cause an issue because now you violated your bond by drinking and then trying to drive. So that's how they affect day-to-day life. The other one, I think you mentioned no contact. The problem there is, and I'm in a small community. Galveston County's not that big, but Galveston, we're on an island. And so you have the issue of my clients often ask me, what if I'm at the grocery store and I see the victim? What do I do? Well, you just turn around and leave. An accidental encounter can't be a violation, but don't further the interaction. If you have someone you're not supposed to be around and you're in the grocery store and you see them, just turn around and go and come back later. So it's going, the conditions can obviously affect your day-to-day life.
Very clearly. Very clearly. If someone believes a condition is unreasonable or impossible to follow, what options are available to revisit or modify those terms?
Anything you can imagine. So, for instance, if you were ordered to put an intoxilizer on your vehicle, but your vehicle was wrecked and you don't have a vehicle anymore, whatever the case may be, then we have to go to court. And either, depending upon the judge, we can do a non-driving affidavit, which is where you sign a document swearing that you won't drive, or we can ask for a handheld device, or we can ask for a scram. A lot of times, no contact provisions we have to deal with. The biggest reason for that is usually the exchange of children. But whatever the condition is, if we have to deal with it, we can go to court and deal with it. If you have travel restrictions, we can, and you need to travel, we can go ask the judge, tell them why you need to travel and what dates, and get that permission. If they are affecting you so bad that it is affecting your daily life, there are ways to address it in court.
So there's options. With for people facing criminal charges, how do you express the importance of taking your bond conditions seriously from day one? And how do you make sure they have a clear understanding of those rules to prevent the case from getting worse?
Well, here, if you get bond conditions, first they get a copy of them in writing and they have to sign it. So it shouldn't ever be the situation that they say, I don't know what my bond conditions are and I don't know how to follow them because they signed it. We don't have a lot of problems with people violating their bond conditions because it's made so clear to them before they leave the jail. You have X number of days to get a device. You have 90 days that you have to stay away from the complaining witness. It's very specific. Now, the biggest one is don't go home. People get out all the time and then say, what do I do about my clothes? What do I do about my car? It's still at the house. And so they are subject to bond conditions. I am not. So it has been the case where I have had an investigator call the complaining witness and make arrangements to meet my investigator somewhere to exchange clothes, laptop, things for work, what have you. That's permissible because it's going through me in my office and not directly from the accused. So, believe it or not, we don't encounter a lot of problems. The no contact is the biggest one that people have trouble with because they also get out of jail and then say, look, they won't stop calling my phone. I'm like, you can't answer it.
Yeah. Mark, this is a lot of clarity around all these different issues. Thank you so much. I appreciate all the information that you shared with our guests today.
Thanks for having me.
Yeah, that's it for today's episode of Defense on the Coast. To learn more and to get help navigating bond conditions in Galveston, Chambers, and Harris County, visit texascriminaljustice.com. And don't forget to leave a review, and subscribe to the show so you don't miss an episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.